All right, you're on a hot mic. Before you go, pop up. All right.
Okay.
Judge Shapiro, the parties are here when you are ready.
Christy, I need a few more minutes and I'll be right back with you.
Okay.
Thank you. Christie, I'm ready to proceed.
Okay, and here come the parties.
Ms. Roberts, are you there?
Yes, Judge, I am.
Ms. Roberts, are you ready to proceed?
Yes, I'm ready, Judge.
All right, very good. All right, I'm going to call this case. It's Court of Claims number 23-116-MB, Michael D. Meyer versus Michigan Department of Corrections. And we're here on multiple motions from the plaintiff and motion to dismiss from the defense. I want to start first with the motion to dismiss. And I guess this is it. Am I saying it right? Langschwager?
Anything close. You got all the letters in, you didn't add any. So
Okay.
it's Langschwager. Langschwager is good enough for me.
All right. Let me see if I can turn the volume up here so I can hear you better. I don't have to do that. All right. Can you guys hear me?
Yes, Your Honor.
I can.
Mr. Meyer, you can hear me?
Yes, sir.
All right, very good.
Can
And
you-
if you keep your voices up, that would be helpful. So, Mr. Meyer, first I'm going to listen to the defense counsel argue his motion to dismiss. Some of those arguments he's going to make will overlap with some of the motions you've brought, and we will get to all of those. But before I do that, I don't want to forget a couple of things. One is I've already issued an order denying plaintiff's motion to strike. And I've also issued an order striking plaintiff's jury demand. Mr. Meyer, you're not permitted to have a jury in the court of claims. No one is. You only get a judge determination, all right?
Okay.
In addition, I want to let Mr. Langschwager know that we received an email, my office did, on December 26th, apparently forwarded to us by Mr. Meyer's brother, but signed by Mr. Meyer. And I instructed the clerk's office to send you a copy. Do you know if you received it?
I don't recall receiving a copy. What was it?
You know, I can barely hear you. Let me figure out how to make this
All right.
louder. Boy, oh boy. Christy, is there anything you can do to help me to make this louder? Let's see. Oh, where'd everybody go?
There should be a button. You won't be able to hold it down, but you should be able to press it a couple times and turn it up on that speaker that's below your computer.
Well, now I have nothing. I lost everybody. I don't know what I clicked on, but
Up at the top, if you are able to see gallery.
no, I don't have. I'm back to the webinar registration and launch meeting.
You are still in the meeting.
There we
with-
are. I apologize. I got it. Okay. All righty. I don't really know how to make it louder. So if you gentlemen could keep your voices up, it would help me very much. So Mr. Langschwager, you indicated that you didn't receive, or you're not sure if you received this email, correct?
I don't recall. What is it entitled?
It's Mr. Meyer is identifying his Court of Appeals docket number, that he has a hearing on a motion for new trial to be held on January 17, and therefore asking that we get to his motions, which we're doing today. And it also cites People v. Kavanaugh, 320 Mishap 293, in which I issued a concurrence that he references. That's it.
I don't believe I was ever given that copy or copy of that document.
Well, I will double check, and if it hasn't been forwarded to your office, I will make sure it is.
All right. Thank you.
And Mr. Meyer, you cannot communicate with me directly. Patients have to be sent through the clerk's office with a copy to defense counsel. Is that clear?
Yes, sir.
All right, very good. Thank you. All right, now we can proceed with the motion for summary disposition. Mr. Langschwager, it's your motion.
All right. Thank you, Your Honor. It pretty much my brief has arguments that there there's a failure to exhaust in advance of the hearing. That the petitioner or plaintiff did not use the proper exhaustion method, and therefore barring him from the complaint. He also has he had a concurrent case with his thumb drive in Ingham County that I believe is still ongoing, because I just received a notice that he was going to claim an appeal on that. So that case was not decided in his favor, and it was decided that he could not keep the thumb drive.
Well, let me ask you there. I'm a little confused about this circuit court matter. My understanding is the trial court said, I'm sending it back to the DOC for some type of additional proceeding. Is that what you're referring to now?
That is correct. And they issued a declaratory ruling that he could not have the thumb drive consistent with the misconduct finding.
Okay. So in other words, there's been a ruling from the DOC on his request for a declaratory ruling regarding a right to legal materials, even if it comes on a CD or DVD, right?
Well, in this case, this would be for the thumb drive, not the CD or DVD.
Okay.
The CD or DVD is a different matter, but closely related. And that was another one where he failed to exhaust in advance of pursuing his claims before this court. And under the Michigan PLRA 600.5503, he has to exhaust prior to filing in this court, which he did not do.
All right. I went through the materials, and it looked to me like he had a level 3 receipt in the guitar matter. Am I mistaken, or what did he?
That one was one where he was untimely. That's why his the grievance process was rejected.
So in other words, the position is even if he grieves and then appeals the result, if it was for failure to file timely, that's the end?
Failure to file a timely grievance would be the end in that case.
I understand.
He has to use the correct grievance process, and that's consistent with parallel federal law.
All right. Anything else on the? Let me grab this and see what I've got here.
Judge, I can't hear you say anything else on what?
Hello, Ms. Roberts, did you say something?
Yeah, I didn't hear you because you turned away. You say anything else on what?
Oh, I just wanted to see if there was something else in the motion for summary disposition that he hasn't, Mr. Lankrager hasn't addressed yet. Can you tell me a little bit about, since I've got you and I know that Mr. Meyer's going to argue it. I have from him some documents indicating that he has paid his court costs or other fees. It's not clear to me whether restitution was paid, and then you've submitted documentation showing that there's still outstanding. Are there any the materials that you submitted regarding outstanding
Court debt.
Yeah, has there now been and that is what's now being recouped out of any funds that he has? Is that right?
It is my understanding that that's the basis for the collections. He still has outstanding court debt.
That's the basis of the what?
Or the collection from his account.
Okay.
He had several criminal cases.
So, all right, and I want to go back for a moment to the declaratory judgment motion, and I understand he filed that in front of Judge Jamo.
That is correct.
Sent it back, and now there's been a declaratory ruling from the DOC, and is that being appealed out of Judge Jamo's court?
To my knowledge, he has not appealed the declaratory ruling.
Okay. So tell me your position on whether or not I'm obligated or can review his request for a declaratory judgment that he's filed with me.
Well, in this case, the request for declaratory judgment, you have a problem with Teddy 23 versus Michigan Film Office. 313 Mishap 557.
31, say it, I'm sorry, I didn't hear you.
It's 313 Mishap 557 at 567.
Okay.
It's a 2015 case.
Uh-huh.
And basically you have 600-6419 subsection 5.
600-6419. Let's see if I have that. I do. Just a moment. I think I do. Just a second, please. Well, I thought I had it. All right, and why don't you just tell me what that statute says?
Well, in relevant part, it says this chapter does not deprive the circuit court of exclusive jurisdiction over appeals from the district court or administrative agencies as authorized by law.
So is it your position that any request for a declaratory judgment has to be filed as an appeal from that matter an appeal to the circuit court?
It would be, because it's an appeal from the administrative agency. And that's what he has ongoing right now. He filed a claim of appeal that we just received a copy today.
Oh, he did?
Yes, Mr. Meyer can verify whether he's filed a claim of appeal on the docket
Okay.
ending in 210.
All right, so let me ask you, and I'm not doubting your good faith, but I just want to confirm. I mean, is he going to be seeing a motion in the Court of Appeals that he should have filed in the Court of Claims?
I do not know. Oh, you're
Okay.
talking about from me. You should have filed this in the court of, no.
No,
because
that he should have filed the administrative appeal
No.
from the.
No, because with the administrative appeal under 1023,
Yep.
if he's claiming an appeal from an administrative decision,
It
it's
has
got
to
to
go
be
to-
in the circuit court.
All right, and did he file a claim of appeal or I don't even know whether
He just filed a claim of appeal recently in the Court of Appeals, or at least we have a copy of it. I don't know if the court's accepted it.
All right, I haven't seen it yet. Let me go to Mr. Meyer just for a second. I'm going to come back to you, Mr. Langschwager. Mr. Meyer, is that correct that you have now filed a claim of appeal from the department's administrative ruling that you are not entitled to electronic versions of court records?
No, that's not what I filed a claim of appeal in the Court of Appeals.
Yes.
Right, but I'm not appealing whether or not, because no decision has actually been made by the agency. What I'm appealing is the right to a hearing, a contested case hearing within the department under Chapter 4 of the Administrative Procedures Act.
All right. Do you have the number of, have you been assigned a number for this appeal?
No, I don't even know if they've received it yet. But I would like to point out to the court, if I have a moment, if you can hear me.
I'm going to give you lots of moments, but if
Okay.
it's about that appeal, I want to know, but otherwise hold on to it. Okay.
Okay,
All right. So it sounds to me like this issue of the declaratory judgment is not sufficiently clear on the record for me to make a determination in the request for a deck action, at least for on the substance. I'm not in a position to make a ruling on that. There may be procedural reasons why it should be dismissed, but I'll have to see when I see the relevant filings. Okay.
All right,
So-
Charlie, if you like, and I'm sorry for interrupting. I can send you material that gave him the agency declaratory ruling on this.
That would be great. If you would just send that to the clerk's office.
All right, thank you.
All right, and send a copy if you're able to make copies to Mr. Langschwager.
I'll send it to Mr. Meyer as well.
No, wait, who's going to send it to Mr. Meyer?
I will.
Oh, okay, you
He's
have it, Mr. Langschwager.
Yes, and in fact, he
I'm sorry, I
attached it to one of
misheard.
his documents that he filed with this court, if I'm not mistaken.
I did file a notice to the court.
I've sure got a lot of things here, so I'm a little confused perhaps. Hang on, please. Let me see. All right. So do you know when you filed this approximately, Mr. Meyer?
I believe the 27th.
of,
December 2023.
oh yeah, well, I don't see it filed in the court. I don't see it filed in the Court of Claims, and without a number, I don't know that I can get to it in the Court of Appeals. Okay, well, I don't know that I can do anything about that.
If I could, Your Honor, under the administrative rule,
Well, you
the
know what? Hold
agencies-
on, Mr. Meyer, before we get into your full argument, let me conclude here with Mr. Langfrider. So you've talked to me now about the failure to exhaust. And as I understand it, there are 4 different issues that regarding possession of documents or materials. There's the guitar and the strings. That one, you tell me the grievances were not exhausted because it was untimely.
Right,
Then we've got the one about the funds.
right. And that one, I think we addressed directly and said that, well, first off, he didn't exhaust. And the second one is we have nothing that says that the agency can supersede a court order to collect that money.
Right.
So
Okay.
the court order out of either Ogama or Aranac, those are golden until he goes to the court and gets those changed.
Do you know why there was a period of time where no funds were being deducted? Which
My guess
seems to
is
have led Mr.
somebody
Meyer to
had made a-
believe.
My guess that somebody had made a mistake somewhere because those funds are due.
Okay,
You know, if they had satisfied the funds and those courts, they're supposed to contact the department and say, department, stop collecting.
all right. And on the CD and the thumb drive,
That was a failure to exhaust. He had
okay.
not exhausted prior to filing this claim.
also because of untimeliness?
Well, in that one, I would have to look at the grievance through all 3 steps to give you an answer, but at this time, there is definitely a failure to exhaust.
Okay,
And going back to the thumb drive, I think a C6 motion is warranted here because you can't have this case in 2 different courts.
right. So can you tell me, Mr. Langfrider, what do you know what Judge Jamo did in the end? He ordered it to go back?
Yes, he did.
Wait
He
a
had
minute.
ordered it back to the department. The department issued a declaratory ruling on the thumb drive. Said he
Right,
can't have it.
that's the one that you're saying he can't have it in 2 places at once.
And the fact that it was ongoing with it was
Got it.
it was not, we never had a final order prior to coming to this court and asking for basically the equivalent relief or,
Okay. And your position is that matter is now before the Court of Appeals, and Mr. Myers indicated he doesn't believe that that's what is before the Court of Appeals, and only reviewing the materials and what order is being appealed, I guess, will allow me to make
Yes.
that determination.
whatever he's appealing, it would be in the Court of Appeals, it would be the whole case.
All right. Let me just look at my list here. Is Mr. Langfrider, does the department still have possession of the thumb drive and the CD or DVD? Looks like maybe you never had possession. Do you know the status of those?
Is that to
Mr.
Mr.
Langfrider,
Meyer?
I'm asking you.
What's that?
Do you know the status of the thumb drive? Is it still being
According
held
to-
by the department?
According to the ex parte motion that I just obtained a copy of today after requesting it from the court, they still have a copy of the thumb drive, but I don't think he was ever allowed to possess the CD/DVD. I think there was a rejected mail and it
And
does
that
not
went
go to
back
the
to the sender,
institution.
that would have gone back to the sender, which was the
Yes.
court, right?
Yes.
No, they still have it. They still have it.
Okay, Mr. Meyer, did you, to your knowledge, did they have the CD/DVD or was that sent back?
No, Administrative Assistant Fager still has the CD. He asked me
Correct.
to sign a disposition just weeks ago. That's why I filed the request for a temporary restraining order.
Okay. All righty. Mr. Langfrider, anything else you want to say about the SD motion?
Well, I didn't know that they still retain the CD DVD. It's good to know. But at this time, I believe that the matter has been adequately briefed and that based on subsequent procedures in Ingham County, this is now a C6 or a C7 as an alternative argument because it's raised judicata. The matter has already been decided.
Who decided it?
Well, Judge Jamo would have decided the case when it was up for a declaratory review. Plaintiff also filed a motion for relief from judgment after he received the declaratory ruling. And that motion went against him. Judge Jamo denied the motion for relief from judgment.
I see. Whew.
And the relief that I was asking for was a hearing, not for a declaratory ruling.
Okay, I understand. All right. Mr. Meyer, before we get to your motions, as I read your response, your view is that any attempt to have filed additional grievances would have been futile. But the fact is that whether, I'm not sure, I think it's very fair, but the law says that you need to timely file your grievance, and it appears that you haven't. Can you respond to that?
Yes, I can. As I stated, let's talk about, I guess, the guitar first.
Okay.
And attached to my, or I'm sorry, the defendant has an exhibit list here, and his first exhibit is PDO 302-130, and that is the grievance procedure.
Yeah.
And it clearly states in the grievance procedure,
One moment. Yeah, I got it.
let me find. And I stated this in my answer that I did timely grieve it pursuant to the grievance procedure.
I think isn't it like 5 days after you first attempt to resolve it
Right,
informally?
right. But the thing, there's a caveat to that. If I could just find.
Yeah, go ahead. Take your time.
Okay. Okay. Trying to think.
Well, is there anything else other than futility that you're relying on?
No, I'm relying on the grievance procedure itself. It says that you can attempt to resolve the issue within so many days of becoming aware. That's why they thought it was untimely, is because it was 2 weeks after the incident, but I didn't become aware of the grievable issue until the day that I actually filed the grievance. I sent a kite to Mr. Plews saying I was supposed to have a hearing, and then I filed the grievance additionally because I expected not to hear from him anyways.
So I don't. I think the defense position is, well, once they took your guitar, that was time to file the grievance.
No, because I wasn't aware at the time that I even had a grievable issue. I was going based off of what I was told by Officer Plews, or I'm not sure what his title is. He's not an officer.
Okay. All righty, and do you have and as to the other items, the CD, the DVD, or the USB, the funds, do you contest that you failed to exhaust in those cases, and what was the reason there?
Yes. Okay. So for the funding issue, I had previously grieved this, and I attached to my complaint a copy of that grievance. Right?
Yeah.
Let me see.
This
If
is
you
on
look
the
at my
funds,
amendment,
right?
Yeah, we're talking about the funds right now.
Okay.
If you look at, there's an attachment to my amended complaint. It's going to be well, I don't have it labeled or anything, but it looks like this.
I can't see it, but it's okay. I remember seeing something about it that couldn't be grieved again.
Okay, and it says right clearly in the policy that once you've grieved an issue that are duplicate of those issues raised in another grievance filed by the grievance. So I couldn't grieve it again because I'd already grieved it once in January, 16 months prior, and it was already resolved. They stopped taking money because it says right in the investigation summary, it says MDOC received a satisfaction of financial obligation from the 23rd Circuit for two of the cases. And then also I attached to my amended complaint in my original complaint, the satisfaction of financial obligations. And those are dated.
And that's dated December 21 of 21. And that
Yep.
is at Ogama, right?
Yep, there's two of them there for two different files. And if you look, one of them even says received accounts payable.
Okay, hold on one moment. Okay. Well, I also have, and the defense has presented a document dated October 20, 2023, which shows an outstanding balance from Ogama/Roscommon of $6,962.
Right.
What is your answer to that? And it doesn't appear from what you've given me necessarily that the restitution was paid. But go ahead.
No, I'm not arguing that it was paid. I'm arguing that the court waived it with these satisfaction forms, I guess. I don't know how they were received or where they came from, but what I'm saying is there was no current court order. What he's giving you is a printout of what I owe. I'm not denying
Right.
that I still owe them. I'm just saying that that's not an order, and the MDOC can only act on orders. And the most recent thing that they have is the satisfaction of financial obligations, which they were adhering to for 16 months or however long it was, whatever the case may be.
One moment, please.
Yep.
All right. Thank you. I'll review those materials. I understand your argument. And then we have the USB and the CD. Were those grieved?
Well, the USB I could not grieve because per the policy grievance, it says that the grievant cannot grieve a misconduct. I was given a misconduct for the thumb drive, so I can't grieve that.
Okay.
Right. And as far as the CD goes, I did grieve it. And he's right. I didn't. I filed this appeal, or I'm sorry, this claim prior to exhausting those remedies, but I knew that they were going to be futile. And I clearly predicted correctly because now that they've fully been exhausted, you can see, as my exhibits show, that it was worthless. It was falling on deaf ears.
Okay. All righty. So now let's turn to your motions here. I have, let me get my list, sorry.
I would like to make one more quick argument for you. If
One
that's
more
okay.
what?
Quick argument regarding the
Yeah,
exhaustion.
go ahead.
Okay, pursuant to Administrative Rule 324.74, it says the paragraph 5 there, the final agency decision in a contested case.
Paragraph what?
5.
It says in paragraph 5, okay.
Yes, ma'am. The final agency decision in a contested case is the exhaustion of administrative remedies as set forth in section 301 of the act. And the final order of the agency was the declaratory ruling that they just made. And the judge denied me relief in the form of a hearing. All I asked for was a hearing. I didn't ask for him to make a declaratory ruling. So it has been exhausted, even though I'm appealing the question regarding a hearing, a contested case hearing. The administrative remedies are exhaustive pursuant to the administrative rule.
Okay. And sadly, I have misplaced my list of motions, which was a lot. So give me a second. Let's see if I find it.
Okay.
Your Honor, I believe they're all listed on the notice of hearing.
Yeah, I'm gonna pull it up right now. Okay, very good. All right. I understand your motion for possession, Mr. Meyer, and tell me, what was the proceeding you're having in trial court on the
Now,
17th?
I did not provide the court with a copy of this, but I have a copy of a notice to appear. I don't know if you want me to show the court. It's a motion for new trial.
Right, that I understand. I know what that's about. So
Okay.
you're arguing that there's new evidence or something like that.
Yeah, I'm re-raising my motion to suppress, which entitles me to an evidentiary hearing. And there's some audio on the thumb drive. There's some video footage on the thumb drive, and it's impeaching. And there's also photographs.
And let me ask something. How come when the department was willing to send the drive to someone on the outside who then could have printed it and provided you with paper copies, why didn't you do that? That could have been done months ago.
Well, for one, I don't know how I'd print off audio or video footage.
Well, putting that aside, a lot of it is documents.
Well, there's hundreds of thousands of pages worth of documents. My case is not a simple case. There is quite a bit of discovery. I mean, we're talking over 50,000 pages just from a cell phone data dump. And there's 3 cell phones involved in my case. You got years worth of call detail records that are on Excel spreadsheets. I mean, it would be unrealistic to even try. Plus, to be honest with you, Your Honor, I'm an orphan. The only family I have is a brother. And I wouldn't ask him to do that. And he lives in Chicago as well. So it's like, it's just logistically, it would be extremely difficult.
Okay. All right, the motion for declaratory relief, I feel like we've discussed. The motion for leave to file supplemental pleadings and proofs. I'm not sure what it is you were seeking to file at that point. Was that?
I'm sorry. No, I'm learning this as I go, so I'd like to apologize. When I said pleadings, I meant a supplemental response to the plaintiff's. Right.
Okay, all right. Now, tell me about, so I can follow that. Now your motion to hold counts 2, 3, and 4, which is the funds, the CD, and the thumb drive in abeyance. You know, where is that at in terms of, I mean, are you still seeking that?
Well, you know, I just wanted to preserve it if this court feels that because of what's going on either in the Court of Appeals or in the 30th Circuit, because this has been evolving at the same time. You know, I didn't know what your position was going to be, so I just wanted to preserve the arguments that a stay is more appropriate. And I think there's actually statutory authority for a stay. It'd be MCL 600.6419, or wait, I'm sorry.
That's right. You don't need to cite the statute to me. That's okay.
Okay, but yeah, I think plus the case that I cited in my motion says that a stay is more appropriate than just dismissal.
Got it. Then I've already ruled on your motion to strike, which I denied.
Okay.
And I understand your TRO request, which is essentially to retain, if they're not immediately providing you with the material, the electronic materials, you want them to retain it, right?
Right. Just hold on to it.
Okay. So have I covered all your motions, or is there some others that we haven't even referenced?
Well, I would like to talk more about the request for declaratory ruling. I don't know what your position is, or whether you're even going to allow, or
That's
even.
fine. You can give me an argument on the merits if you want.
Okay, cool. I believe the core of it is inmates' right to have access to the courts, which is a constitutional right. And state law clearly creates liberty interests. And the core of my argument is a specific statute, MCLA 100.42, defines prisoners' legal property. And it's the same language from MDOC policy, right? So, and it defines prisoners' legal property as documents, exhibits, or items necessary for litigation, right? And exhibits are defined by the Michigan Rules of Evidence as audio and video recordings. The Michigan Court Rules defines documents per MCR 1.109 as audio and video recordings and discovery materials. Discovery defines audio and video recordings as discovery materials. I mean, this court is well aware of the best evidence in court is audio and video recordings. If there's any question between a witness's testimony, the best evidence would be the audio or video evidence. So I think to not allow prisoners to have access to these materials for whether it be a motion for new trial or an offer of proof on a motion to remand in the Court of Appeals, or if they had to retain their own exhibits in a civil case that they're pursuing, which I'm doing right now, right? I should have a right to those materials. It's tantamount metaphorically to telling somebody, you can defend yourself. I'm going to give you this weapon. Here's this gun, but I'm not going to give you any ammunition. It's like
I understand your
allowing
argument.
people. Okay. So, and that's the core of it.
I mean, it's
And
the
in my-
tension between the right to have your legal materials and the
Sorry, Judge,
department's
can I-
right to determine. I'm sorry, Ms. Roberts, what?
You kind of were talking over the other,
Gotcha.
can you say that again?
I said there's a tension, obviously, between the right to have your legal materials and the department's authority to limit how those materials come to you. And I understand what you're arguing, which is that the right to have those materials trumps whatever they've got in terms of limitation on the form, right?
Absolutely. And there should be a meeting in the middle somewhere.
Right. Well, obviously, this raises an administrative question that goes beyond me, which is, the courts are sending people things on discs, and DOC, for security reasons, doesn't allow those. When somebody's got to figure out a new way to handle that, but I don't think that's me. Okay. Is there something else before I go back to Mr. Langschreiber, Mr. Meyer, that you wanted to cover?
I would just like to point out to the court, I also have filed in the Court of Claims a review of the misconduct, which I know is a question in the SD motion. So
The misconduct regarding the CD?
Yes. No, the thumb drive. I wasn't given a misconduct for the CD. The CD was just a mail rejection.
Well, one thing that might short circuit your argument is you also had the tattoo needle.
Right.
Isn't that a sufficient basis on which to uphold, assuming it's properly before me, isn't that a sufficient basis to uphold the finding?
Well, you're right. Yes. And I'm just really covering my basis even by appealing it, because, the agency's final order and the request for rehearing said it was vague. It said that the ticket was being upheld for the tattoo needle and the ALJ couldn't make a dispositional finding, but that doesn't really answer the question on whether I should be able to have it. So I'm just really covering my bases, but honestly, if anything, yeah, it would uphold the guilty finding, but I think there might be a remand there for a new hearing to determine the question regarding the thumb drive.
I understand. Okay. Mr. Langschreiber, what is your response to his argument that he's not permitted to refile a grievance concerning the funds since he did it earlier and then they stopped?
Well, that would be when he had the case for one order or an order that he's satisfied, but that doesn't mean there aren't any other orders out there. And obviously there's other orders out there based on what I attached. So they don't have to issue a new order of restitution. That old order of restitution is fine.
I understand, as long as it hasn't been paid, for sure, it's fine. So I guess I'm just confused as to which order is which, but I'll go through them. But I understand, Mr. Langschreiber, what you're saying is he was grieving about collection of payment on one file, but there are other files.
Yes. And here's something else to add to this is that as far as the declaratory ruling, after an alleged injury occurs, there is no actual controversy for declaratory relief. And that's Lansing Education Association versus Lansing District Board of Education, 293 Mish App 506 at 516. That's a 2011 case. And so he's had these issues determined against him. And so to go to the court and say, decide this again, that's not what declaratory relief is supposed to be for. It's supposed to be to avoid injury before it occurs. That is the purpose.
Okay. Anything else you'd like to respond to?
I would like to say that the petitioner plaintiff has been sending material to the department and myself. Any material is supposed to come to me, not just the department. And as you alluded to at the beginning, his brother had contacted you, so his brother is a source for helping him with his proceedings. And he had an ex parte motion that this court has referenced. And so that would be another instance of him not sending.
Which one is that?
I'm sorry, what did you say?
The plaintiff's motion for temporary restraining order
Excuse me,
filed December
I
4th.
didn't hear what the judge said, because.
I said which one, all I said was which one is that? And Mr. Lantrager, why don't you repeat your answer?
It's the December 4th, 2023 document that you referenced in the notice of hearing. And it does say ex parte on it, because I obtained it today.
Okay.
If you do, I'll hold you tonight.
All right, Mr. Meyer, do you dispute that you did not, that you filed the TRO as ex parte and haven't copied the defense counsel?
Actually, Your Honor, yeah, because I was under the impression per the court rule that you could file an ex parte request.
You can file an ex parte request, but once the case has begun, in other words, this TRO request arises in the context of a case that's already pending. So if somebody wants to go into court and get a TRO, they can get one for a very brief period of time, but they still have to be filing a motion for preliminary injunction, which has to be served. But in this case, the case is already pending. So you should have served defense counsel, and in the future, anything you file with the court under this matter needs to be served on Mr. Blankschweiger or his colleague.
Okay.
I got that, Mr. Blankschweiger, on the TRO. Anything else?
Yes, and speaking of my colleague, Mr. Soros, he informed me that the jump drive doesn't just have legal documents on it. Apparently, there are pictures of his dog and Christmas party pictures.
This is which
The jump drive, the thumb drive.
But
So it's not just legal.
One second, I thought the ALJ had someone review all of that. And I have a list
Mr. Soros
here.
was able to see pictures of a dog and pictures of a Christmas party, and Mr. Meyer can come clean and tell the court whether that's true.
Mr. Meyer, do you know whether that's true? Regarding personal photos on the disk?
And the thumb drive.
On the thumb drive, pardon me. I'm a little confused, though, Mr. Langford. I thought the thumb drive came directly from the court.
No, the thumb drive did not. Apparently, the mail with the CD, I don't know, Mr. Meyer might be frozen because he's sitting there pretty expressionless.
Oh, Mr. Meyer, can you hear me? He is frozen. Christy, is there anything we can do to help unfreeze him?
Not that I know of. No, not on our end.
Can he hear you?
Nope. And
Well,
he just
he's
went,
gone.
yeah. I will keep an eye out to see if he will be able to come back, because they may be
Okay.
restarting and then coming back in.
All right.
And as soon
Well,
as
go
I
ahead.
see them, I will bring them back in.
Fine. Well, the record should reflect that Mr. Meyer has unfortunately been removed from our conference due to some technical problem. We're on Mr. Langschweiger's rebuttal. I'm going to let him continue. And if need be, I'll advise Mr. Meyer of what was covered. So go ahead.
Well, I think we have to have Mr. Meyer here, unless you want to go over any other ground.
You were just, well, I'll relay it in, but would you explain to me what you were saying about the thumb drive not being coming directly from the court?
Right, the thumb drive was found hidden in a bar of soap.
Oh, right.
And the CD/DVD, whatever the circular document, not document, circular storage format was sent in the mail.
All
And
right.
the mail was rejected, so it was not supposed to be in the institution, but obviously if the administrative assistant still has it there, it's in the institution, just not in the possession of Mr. Meyer.
Okay. Well, Christie, has there been any attempt for him to sign back on?
There has not.
Yeah.
It may have been a time issue. It may have timed out, or
Mhm.
they may have just had to restart.
All right.
I know last time they just were able to come in. So I am keeping an eye out, but I don't see anything just yet.
All right. Well, Mr. Langschreiger, in your view, is there anything else that you wanted to cover?
Not at this time.
All right. And I feel as though I've heard whatever Mr. Meyer has to say. We'll wait a couple of more minutes. If he doesn't sign back on, then I'll just indicate that the hearing is concluded. I'm going to take myself off video and audio right now, and in 2 minutes I'll come back. And if he's not there, then Mr. Langschreiger, I'll let you go. If you want to close out your audio and video in the meantime, you're welcome to as well.
All right, thank you, Your Honor.
Mr. Langschreiger? Ms. Roberts?
Yes, Judge, I'm here.
All right. Mr. Langfry, are you there?
Yes. Just, I'm gonna get my video going. Yes.
Well, unfortunately, we've lost communication with Mr. Meyer. However, given the fact that he reviewed his motions orally, he laid out his defense to the summary disposition motion.
Oh, there he is.
Mr. Meyer, just in time.
Just in time.
The only thing you missed before we put things on hold was I was asking Mr. Langschweiger about the thumb drive and coming from the court, and he reminded me that actually this was found in the bar of soap, that while the CD and DVD came directly from. Right. All right.
I did want to say that he was accurate about, the pictures he had mentioned on there. And I provided the court in my exhibits, the proofs of service that were given from the lower court in my criminal matter. And one of the search warrants was a Facebook search warrant. So that's why there's personal photos that were included.
Good. Well, I'm satisfied having heard all the motions. I'm going to sit down this afternoon and hopefully get an order out, if not very, very quickly, because I know you have your hearing on the 17th. Let me ask you one more thing, Mr. Meyer. What is the basis? You don't have to, make an argument. Can you tell me what the basis is for your motion for new trial? You're alleging evidentiary error?
I'm alleging a Fourth Amendment. Well, there's a couple things going on there. I got a few issues. I consulted with experts prior to trial.
I know.
And I worked with MIDC regarding funding for my expert. And just days before trial, MIDC refused to pay my expert. They basically ripped him off. And those communications are not on the record. And those communications are on that thumb drive. Some of them, not all of them. Some of them I've included in my motion for new trial, but I want that on the record. And then As far as the Fourth Amendment goes, let me shut this door. Hold on a second. And then as far as the Fourth Amendment issue goes, I was pit maneuvered at an intersection during an investigative stop.
Yes, that I read.
Okay.
And that was not challenged at any time?
I did file a motion to suppress prior to trial, and their testimony was that I was stopped when they turned their lights on.
You don't have to tell me what happened. Just tell me what happened. Was the motion just overruled?
It was.
In other words,
it was denied. Yes,
denied.
But the testimony changed at trial. I didn't have access to the photographs and some of the video before the hearing, so now I have an opportunity.
Issue appealed.
I'm sorry.
It will be.
What did you say?
I said, was the issue regarding, now I'm confused, not the Fourth Amendment, the, what did you say, Mr. Meyer, was the other one?
The expert?
Yeah, was there an appeal taken from that after your conviction?
I'm representing myself on direct appeal.
Oh, I see. That's what's before the panel now. I appreciate it. Now I understand. And you've asked them to produce order these materials produced, and they denied the motion, correct?
No, I filed a motion for new trial, which I'll have a hearing and an opportunity to put this stuff on the record.
All right. Well, let me ask you, if what you need are materials specifically related to your expert, why do you need 50,000 pages? Why can't your brother simply go through or a request from the court the specific materials regarding that?
That's complex. I mean, to be honest with you, my brother, he's not an attorney and he can't represent me, for one.
Right,
That's illegal. It's illegal for him to do that. And number two,
to file things with the court. I'm just wondering if you might be able to get what you want without getting the rulings that you want here, because you might not get them.
Well, that's true. And just to give you an example, it was hard enough trying to get him to figure out how to email you. So to try and have him go through call detail records and make exhibits. I actually brought exhibits, but I don't think it's relevant at this time. I made several exhibits prior to trial, and I need software to do that.
And have you filed a brief in your appeal from the conviction? I
Not
don't
yet. That'll
think
be
so.
that'll be after the motion for new trial.
Right, which is the same. All right, very good. I'm satisfied that I've heard all the argument I need. Are either of you concerned about anything I might have missed?
No, Your Honor, if you'd like if you'd like the thumb drive, we could send it to you for in-camera inspection.
Well, I don't want the sole copy of it.
All right.
And I don't really need to inspect it. I think I have an understanding of what's on there. Okay.
And I would
Anything
just like
else?
to make, yes, one more quick thing, because there was an argument made about the circuit court's exclusive jurisdiction pursuant to 6419 of the Court of Claims Act,
Right.
paragraph 5 there. Now that actually, they don't have, the key word there is exclusive jurisdiction. They don't have exclusive jurisdiction. They have concurrent jurisdiction with another court. So that actually the Court of Claims Act divests them of jurisdiction pursuant to O'Connell versus Department of Elections, 316 Mish Act 91 at page 101. It's a 2016 case. Binding precedents.
All right. And remind me, maybe Mr. Lancroix, either of you, which is the statute, Mr. Lancroix, you were relying on about jurisdiction?
Jurisdiction, if it's within the Teddy case, Teddy 23. and
Oh,
it-
that's
it is- It is 6419, sub 5,
600.6419.
right.
Very good. Okay, thank you, gentlemen. I'll get to work on getting you a decision out as quickly as I can. All right?
Thank you.
Thank you very much. Thank you, Ms. Roberts.
You're welcome.